Get ready. 5 seconds to go. Start. It is needless to point out that interlocutory orders are of various kinds. Some, like order of stay, injunction, or receiver, are designed to preserve the status quo pending the litigation and to ensure that the parties might not be prejudiced by the normal delay which the proceedings before the court usually take. They do not, in that sense, decide in any manner the merit of the controversy in issue in the suit and do not, of course, put an end to it, even in part. Such orders are certainly capable of being altered or varied by subsequent applications for the same relief, though normally only on proof of new fact or new situation which subsequently emerge, as they do not impugn upon the legal right of parties to the litigation. The principle of res judicata does not apply to the finding on which these orders are based, though if applications were made for relief on the same basis after the same has once been disposed of, the court would be justified in rejecting the same as an abuse of the process of court. There are other orders which are also interlocutory but would fall into a different category. The difference from the ones just now referred to lies in the fact that they are not directed to maintaining the status quo or the preserve the property pending the final injunction, but are designed to ensure the just, smooth, orderly, and expeditious disposal of the suit. They are interlocutory in the sense that they do not decide any matter in issue arising in the suit, nor put an end to the litigation. The case of an application under Order 9, Rule 7 would be an illustration of this type. If an application made under the provisions of that rule is dismissed and an appeal were filed against the decree in the suit in which such applications were made, there can be no doubt that the property of the order rejecting the reopening of the proceeding and the refusal to relegate the party to an early stage might be canvassed in the appeal and dealt with by the appellate court. In that sense, the refusal of the court to permit the defendant to set the dog back does not attain finality. But we are concerned with a slightly different, and that is whether the same court is finally bound by that order at later stages, so as to preclude its being reconsidered. Even if the rule of res judicata does not apply, it would not follow that on every subsequent day on which the suit stands adjourned for further hearing, the petition could be repeated and fresh order sought on the basis of identical fact. The principle that repeated application based on the same facts and seeking the same relief might be disallowed by the court does not, however, necessarily rest on the principle of res judicata. Thus, if an application for the adjournment of a suit is rejected, a subsequent application for the same purpose, even if based on the same fact, is not based on the application of any rule of res judicata, but it would be rejected for the same ground on which the original application was refused. The principle underlining the distinction between the rule of res judicata and a rejection on the ground that no new fact have been adduced to justify a different order is vital. If the principle of res judicata is applicable to the decision on a particular issue of fact, even if fresh facts were placed before the court, the bar would continue to operate and preclude a fresh investigation of the issue, whereas in the other case, on proof of fresh fact, the court would be competent, nay, would be bound to take those into account and make an order conformability to the fact freshly brought before the court. Para. The counsel for the respondent submitted that the trial court has got jurisdiction to remit the commissioner's report or to send a second commission for local inspection only. In the event of setting aside the earlier commission report and without setting aside the commission report, the court will not get any jurisdiction to issue a second commission. He further submits that the revision petition did not object to the commission report and never wanted to set aside the report. The learned counsel referred me to the decision reported in Premananda Bharati versus Yogananda Bharati 1985 KLT 144. Stop.